Thanks everyone for joining in. We're really excited to talk about the rules that have come out and DPDP compliance in general and how you can get started. Today, Puneeth has joined us for yet another session. Thank you so much, Puneeth. For those of you all who are seeing him for the first time, he's a partner in the public policy and regulatory affairs team at Shardul, Amarchand and Mangaldas. And he works on a range of regulatory matters with a specialization in data governance, data privacy, regulation of AI, and telecom. He has a really deep understanding of the law and the legislative process as well. In fact, he is invited to testify before the JPC examining the Personal Data Protection Bill back in 2019. So we have to make the best of our time while talking to Puneeth, and we hope to get a lot of insights from him. Thank you, Puneeth, for joining us yet again when the rules have actually come out.
Thanks so much, Pushkal. It's always a pleasure to speak with you guys, and very happy to be speaking once the framework has actually been enforced.
Yes, absolutely. Now all hypothetical discussions are over, and now we actually get to the brass tacks of implementation. So it really matters now, and I think the audiences resonate with this as well. So very quickly to get into how we are planning on going about it. This is supposed to be an AMA, which means that it will be led a lot by the questions that you all are posting. Our job here will be to structure the session and provide a broad structure for the topics in which we will be asking questions. We have prepared some brief slides for you to talk about the rules and to talk about getting started. Once that presentation is done, we will go across several themes. There are some questions that we have prepared, and then we will open it up to the floor to ask questions. While you're watching, feel free to post questions about the topics that we are talking about. If your question is on topic, we will pick up the question and ask Puneeth. We expect a lot of questions though, so there are some questions that we will not be able to pick up, and those questions we will send you as a written response after the answers to those questions. We will send you as a written response after this session is over. Try to keep your questions on topic. Often, if we have passed that topic and if a question comes for a previous topic, then we will not be able to cover those as well. But the goal here is going to be to give you as much exposure as possible to Puneeth's expertise and to cover as many questions as we can. That is what we are going for. But we have our limitations, and those are our limitations. Now, about the structure of the session, the rules are out finally, and we are here to sit with Puneeth and unpackage what exactly has changed in the final rules. There are enough and more summaries of the rules floating around, so we will not spend too much time on the summary, and we will focus on clarifications and really getting an expert and legal and regulatory perspective on how to interpret the rules and how to get started. Next, we will talk about some critical information that you will need as you get started with compliance. Under this broad header, we will cover some critical aspects of consent and notice design, third-party risk management, one-time notices, and any other questions that you want to ask as well. Before we get into the analysis of the rules, there is a poll that we are launching now, which is, where are you right now? So what stage of preparedness are you at right now? Are you just getting started? Have you begun your initial assessments? Are you doing POCs? Are you at an org-wide implementation stage? Or are you already compliant because you're maybe regulated under global regulations or something like that? Or you just have a very refined privacy program? Yeah, thank you for those answers. Just coming in, I think most of us are just getting started. So that is, and others, I think a quarter are doing their initial assessments. So that is very good context for us. Some have already started doing POCs. Now we can move to the next step. So in the next step, what I will do is I will share my screen and I will quickly go over the key requirements under the rules and what changes from the draft rules to the final rules. So in the DPDP rules, the rules talk about elements of a valid consent notice, which is what all should be there in the notice. It includes the data that is being processed, the purposes for which the data is being processed, some communication links to the preference center for grievance addressal, for complaints to the board, what all goods and services are being provided have to be listed out. And of course, the notice should be understandable separately. and it should be available in all 22 languages. So these are the requirements for a notice. There are obligations and registrations of consent managers. As we know, that consent managers work for the data principal, and they can be used by the data principal to give, manage, review, and withdraw their consents. All the requirements for a consent managers are listed out in a lot of detail in these rules, and they talk about the qualification requirements and the obligations of the consent managers, which are largely to provide this platform and an interface and a login and everything to the users to be able to manage their consents and raise a request and all of that. There are also some standards that are notified for processing personal data by state instrumentalities. There are retention periods that are notified for specified purposes, especially applying to e-commerce companies, social media companies, and such, which talk about once if a user creates their account and it is inactive, how long should their data should be processed for a period of 3 years. There is also another interesting point that has come up in the new rules, which I'll talk about in the next slide. They list out the principles of reasonable security practices. It's a principles based approach. So there's not a compliance checklist of the specific information security requirements that you need to do. This was the case in the draft rules as well. There are principles, and you can pick the standards with which you're going to comply. Your regulator already probably prescribes. If you're regulated, your regulator already prescribes standards for which you should comply. There are, of course, provisions for personal data breach and intimating the data protection board and the data principal when a personal data breach happens. Regulated entities already do have personal data breach protocols, but now the principal is supposed to be notified and for each personal data breach. So that is a big sort of a piece that comes in. There are provisions for verifiable consent of parents or guardians for processing children's data and data of a person with disability. There are obligations of a significant data fiduciary, and the roles and powers of the data protection board are specified. As I said, we will not go too deep into these summaries. There are enough and more summaries that are floating around, and you can take your pick from those. Here, we will just focus on the key requirements and what has changed, right? The key highlights of what has changed is that one key issue that was there when the draft rules came out was that the child, how do you establish the relationship between the parent and the child? And the ministry seems to have put that to rest by saying that the child can self declare who's their parent, and that is adequate. There's also a rationalization of the provisions where provisions relating to child are listed out separately, provisions relating to persons with disabilities are listed out separately for guardian consent. So this is with respect to child, parent, and guardian. There are dates and timelines. Now this is the key contribution, change that has happened with the rules. So the first thing is effective dates are out. The data protection board is live right now. Consent manager obligations will be live from a year from now, and data fiduciary obligations are live 18 months from now. So that is the buzzword, 18-month timeline. If you're a data fiduciary, you have 18 months to comply. Is that enough time? Maybe we will unearth that today. 90-day time period for grievance redressal. So there was some questions about we have to have a time period, but how long is that time period? So now the ministry has notified a 90-day time period for grievance redressal under the rules. And there are also this interesting provision that's pretty much says that all data fiduciaries have to maintain records and logs and user data of all processing activities for a period of 1 year. So how does this shape out? Who does this impact? That is yet to be seen. This is a summary of some of the changes that have come up. A lot of these changes I've covered already. There are some more changes. For example, in the notice earlier, it used to say that data categories must be itemized as well as the purposes must be itemized, and the goods and services must also be itemized. Now they're saying the data categories must be itemized, but the word itemized has been removed for purposes, specified purposes, and goods and services, which probably allows for a neater notice if you take away itemization requirements. But we're yet to see what exactly that means. Another couple of requirements that have come up. First is about cross-border data transfers. Earlier, there was some sort of a restriction that was built into the cross-border data transfers that is now brought back in consonance with the Act. And significant data fiduciaries due diligence. This scope has been increased to technical measures, including algorithmic processing and not just algorithmic processing. So that is one key point that has changed in the rules. So what initial impressions, Puneeth? Do you think a lot has changed? What do the changes really bring in?
From a substance perspective, I don't think there has been that much change. There are, of course, things that you pointed out, like there being a 90-day timeline that's now clear for grievance redressal. the bit about significant data fiduciaries and algorithmic decisions made. Those are all important to flag, but we don't think from a substance perspective. If you looked at the rules in Jan to now, there hasn't been that much change. So if you're thinking in terms of readiness, and that's really where our focus should shift. So I'm just going to spend a couple of minutes just talking about how you can think about whether your organization is ready for DPDP compliance yet or not. There's three broad steps in which you can think about it. It's 18 months. So if you want, for your own purposes, you can split it into three chunks of 6 months. You might be way ahead as well. You can think of this as a scorecard for how far along you are in terms of compliance. So in phase one, you need to really put in the foundational work. The first stage, you may have heard this phrase a lot, is data discovery, figuring out where your touch points are, where is that data going, who has access to it. The second, and this is really important, is purpose mapping. That's figuring out what purposes you held on that data for. Sorry, can you go back to the first slide? What purposes you held on to that data for. And that becomes really important when you think of notice, transfer, and all of that. And finally, mapping the boundaries between a data fiduciary and a processor. When you stop becoming a fiduciary, when you start becoming a processor, what are the obligations you're willing to take on? I think you need to make that check before you seek a counsel or before you start figuring out whether you're a fiduciary or not. It's simply a question of how much responsibility are you willing to take on for that data. You can move on to the next slide. And most organizations we know are kind of there. I think build phase is where I would think most people should be really thinking about, because everybody is kind of familiar with the DPDP framework at this point. Again, please correct me if I'm wrong in the poll. The second phase is where you start thinking of much more operational things. So you might have thought of you being a fiduciary or a processor in particular situations, where you're using third parties and you're handing over data to third parties, screening these vendors or other third parties you're working with. You need to start thinking of a data breach protocol, because that's where the highest penalties are. And for organizations that don't already have in place, this is purely an internal measure, figuring out how do you escalate an incident, figuring out how do you define an incident, defining your own internal materiality thresholds, and the process in which you'd escalate. The consent management architecture, which we'll spend a lot of time discussing now. And again, once you do the purpose mapping in the first stage, you start figuring out where do I have contractual relationships, where do I need to expand these, where do I need to document these, setting up internal accountability standards on how you handle data, and figuring out generally as a organization, where are you in terms of operational readiness. We can move on. So the final stage, hopefully in about a year to 18 months time, you should be here, is where you're ready for full lifecycle compliance, which means that you've done everything with respect to data. You've started mapping it. You figured out who's using data for what purposes. You mapped out the situations in which you need this data, and the retention timeline also you have figured out, which has been a particularly thorny issue which we'll spend time on. Then you move on from figuring out how you're using the data to how you're protecting it. So starting from, do you have access control measures put in? Do you have logs of all the data you're using? Have you put in encryption or other methods to secure this data? Do you have backups in place? This is really in terms of how you implement DPDP compliances. Breach notification, as you mentioned in the very beginning, you're figuring out how and when you're using this data. Now you've come to the complete end, to the most sophisticated form of this, where you define internal trigger thresholds. When do you escalate? How do you escalate? You figured out decision-making charts. So I'll escalate it to this department and they'll notify. And have a notification template ready. There's, of course, ones that we expect the DPB and everyone to provide, but there's enough, I think, documentation available even now based on certain reporting and reporting the Wayfair sector for you to do this. Finally, we started off with mapping different stakeholders who have data. By the implementation stage, you should have already figured out the contractual relationships with them. You should either started negotiating or fully executed these contracts. So this is broadly how I think of the 18-month period. I know it sounds like a lot, but move on to more specific questions.
Thanks for that. Thanks for getting that out of the way really quickly. I think that will answer a lot of questions that might have come up. And as we talk about questions, we have also 7 questions that have already come up. A lot of them are about topics that we'll be covering. But one question is something that we can talk about right off the bat, which is that what is the best organizational structure to implement this program that you have spoken about? There's of course the data protection officer's office that is set up. There are also established CISO teams and other product teams that handle a lot of these flows. And in some cases, a privacy committee is also set up. So based on your experiences with a lot of organizations, what do you think is the best organizational structure to actually implement all of this? What do you think that has worked in a lot of these organizations?
That's a very interesting question. I don't know that there's one particular structure that works in every situation. I think you have to be mindful of what sector you operate in, what obligations apply to you, what are the sensitivities of the data you're handling. And also, I think one thing that's ignored in a lot of these conversations is the capacity of the people doing this, right? For instance, if you staff your privacy team full of lawyers, they may not be able to tell you if a data breach is reportable or not because that's a technical evaluation. So I think you need to start from there in terms of building out your teams. It should be a mix of both legal and technical folks, people who are able to sort of work and collaborate with each other. If you're working in a more sensitive area, for instance, if you're handling a lot of children's data, I think you need to be very clear on, even in your organization structure, on how you're collecting it, on what your touch points are. So you might need to staff up or build your teams in that sort of a way. Some of what you're describing, more formalized privacy communities and things like that, while they do exist, I think they do exist in a lot more processing heavy industries, right? Where decisions are taken in a much more top down way. But I think in some of the sectors where you have B2C businesses, you might need a more sort of reflexive structure that might respond to sort of privacy needs much more quickly. So I'd say the starting point should be identifying what sector you're in, what is the prevalent sort of trend in that industry, and figuring out a structure that works for you.
Yeah, thanks for that. That's super helpful. Okay, there are a lot more questions here, but the good thing is that we will cover those questions in the topics that we're discussing already. So let's, as we said, we will first talk about the rules and then we will talk about getting started. So quickly, just about the rules. First, what I want to talk about is the timelines. You mentioned that, not you mentioned, we have seen right after the rules have been released, the minister now wants to do an industry-wide consultation to reduce the time period given for compliance and make an amendment to the rules. At least that's what we have seen in the latest news reports. Can you share any insights on this? Why is this happening right now, and who will this affect? There is talk of startups not being affected by this. So, do you have any more insights here?
So I know there's been a lot of furor and confusion over this. So I'll start off by explaining the government's position, because the government, since the day the DPDP has passed, has been clear that people should start thinking about compliance. So in their minds, the clock started in August 2023. And to also cover ourselves, we have been telling clients the same thing since August 2023. So in their mind, a year and a half has already passed. So the question very obviously in their mind is, why do you need another year and a half? If you look at GDPR and other laws, it was broadly a 2-year timeline, and we've given you more than enough time. Having said that, and I think it's also evident from the poll we just saw that we are in India, we wait till the final notification to start thinking about compliance in a lot of situations. We also have a lot of very small companies that need to put in a lot of compliance measures. So 18 months itself might seem like a stretch if you're starting to think about compliance today. So I think while these consultations are going on, I think there is still a lot of details to be clarified. I think it would be very helpful to let the government know in what sort of situations you would require more time. And if we think 18 months is adequate, it should be sufficient. The other thing I want to flag is I think at various points, and this law has gone through many iterations, right? There was, for instance, talk of giving more leeway to smaller companies. We don't see that in the final text. So maybe this is a good time to go and make that case. Because if you read the minister's statements carefully, they're referring to big companies that are already GDPR compliant. And we already know that for those companies, it's not really a pain point of changing a few things here and there. I think for companies that are starting off fresh, I think clarifying to the government how big the size of that sector is very important.
Got it. Got it. And I think just to be guided by the questions a little bit, there are a lot of questions on consent managers. So maybe let's get on to the topic of consent managers. So first question right off the bat that I have, which I think covers a lot of the questions that are being asked also, is it mandatory for me as a fiduciary to integrate with a consent manager, or is it an optional thing?
That's a very interesting question because, again, the rules does not anyway say it's mandatory for data fiduciaries to do it, but it says that a consent manager will be available at the choice of the data principal. So that in effect could mean that a data fiduciary has to definitely integrate with the consent manager. Before I answer, I also want to say that there's a year's timeline before consent managers are even set up. So this conversation is still a little hypothetical. But what that means in practical terms is that if a data principal says, I want to use a consent manager to access services, to act as a dashboard for all my consents, a data fiduciary should make that available. But at the same time, what the government has also clarified, obviously highlighting the practical difficulties everybody will face, is there could be 100, 200 consent managers. I think that they've said no to. I think because it's a certification-based regime or a licensing regime, in effect, you could end up having a smaller number of consent managers. which means what the obligation to distill it down on the data fiduciary is that if a data principal requests, you should be in a position to integrate with that consent manager. So what you should be able to do is give the data principal a choice, or give the data principal the ability to exercise the choice of a consent manager, right? So so there should be some facility available on a website, app, platform where someone can use a consent manager. So that does not necessarily mean that you have to be interoperable with every consent manager, so long as you're giving the choice. And again, there's still a year's time. We have to see how this plays out. That is broadly how we are looking at it.
Got it. Interesting. So maybe a separate section on your website where at least the consent managers that you have integrated with can be listed out or something like that could
Yes.
be done. Got it. Okay. This is from the fiduciary's perspective. Now, another question is who is this consent manager? So we have seen examples of account aggregators and we have seen examples in the health sector and all of that. We have seen examples also of consent management in the telecom sector that are coming up and also with digital verification. So there are these examples of consent management frameworks that are in place, but who is this consent manager that is being spoken about? Is it like any application that provides consent management as a tool, as a technology service provider, or is it something more than that? Do you have any insights on this?
Sure. Just to take a step back and give you a background of where this idea originated from, since there's a lot of people from the BFSI sector, it's very clear that MeitY's taken inspiration from the account aggregator framework, which has proven successful with the caution that it took almost a decade to build it. But I think they want to replicate something like that. But again, the account aggregator is not exactly a consent manager, right? It's many other things. But I think the idea is that eventually you want to get to a place, and that's how I at least see it, is because people keep talking about data being the new oil and India is this data-rich country. You want to get to a point where the data market itself becomes legally mediated and the data you're relying on is not going to black markets the way that they are available on any Google search. The idea is that you create some sort of legally mediated framework for data to flow from one data fiduciary to another. Now, that's a very idealistic aim. We're probably years away from it, but that's at least the inspiration. Again, giving you the government sort of thinking on this. So what that means is they wanted to give data principles, and at the data principles end, as you may not remember all your passwords. So how will you remember all the purposes you flagged this to? At the very beginning, this is something the Sri Krishna committee also flagged, saying that there'll be consent fatigue, there'll be notice fatigue. I may not remember everything. So you wanted to create a one-stop dashboard where a data principal can easily access all the consent, the purposes to which they've consented and things like that. So that is the thinking behind it. I don't know that implementation, or at least what's in the framework, necessarily enables that. That's a whole other discussion. But what is required in the law as it stands is that there needs to be an independent entity that's not related to a data fiduciary. We, for instance, received a lot of questions where large data fiduciaries said, we can just build this in-house. They don't want that. They want this to be an independent entity. They will treat them on equivalent to data fiduciaries so that the same obligations kind of apply to them. And it will essentially be, I think it's easier to think of them in terms of an intermediary between a user and a data fiduciary and a sort of gatekeeper of the data principal's consent. So if you have to think of it, I would think of it closer to a password manager rather than a super sophisticated tool. But again, this is yet to be built. And there's a lot of discussion going on the technical architecture and how this will operate. So that remains to be seen.
Got it. Yeah, because there's a question in the chat where it says that if I'm using a consent manager tool, consent management tool, then do I have to integrate a consent manager as well? I think based on what you're saying, the answer to that seems to be consent manager is a different registered category, and that must act on behalf of the data principal for the data principal to be able to control where all their consent is flowing. And at some level, you may be required to integrate with them. You may not have to integrate with all of them, but there may be some integration requirements that may come up, and how that pans out is yet to be seen. Is that a fair summary of what you said?
If I could just add one last point on this, and I think the real devil in this is in the government's vision, they've mandated interoperability. And again, if any sort of person who spent any time building products know that that's the hardest thing to achieve, especially when you mandated it. The government, the RBI, for instance, has in the past mandated interoperability of wallets, and wallets just disappeared overnight. So if you have to think of integration and things like that, in its conceptual design, it's supposed to be interoperable. It means that if I have one consent manager, it's supposed to work with all other consent managers. Which is why I'm saying we need to wait and see how this evolves. Because if it actually becomes an interoperable framework, and again, the account aggregator system on the flip side is a good example of interoperability. So if you're able to build out a system like that and it actually works in that smooth way, you could end up having an interoperable framework which allows for different kinds of integration and data flows. But we're not there yet. We'll have to see 1 year from now where the government is.
Okay. One final question on this topic, which is a logistical issue, but an interesting one. It has come up in the questions. So, consent manager is supposed to come live in 12 months. Data fiduciaries are supposed to come live in 18 months, the legal reality of it. And data fiduciaries may have to integrate consent managers. So, what does that mean for my compliance program? How do I slot in consent managers into this compliance program? From a practical point of view, like how are you thinking about it?
Maybe this is a question for legality. You guys actually build the products. Would you be able to do integration within that 6 month period? But on a more serious note, once you build out these tools, there's a lot of things that needs to happen within a year. You need these consent managers to meet all the criteria that's laid down, get registered with the government, and then actually have a proof of concept. There was this business document that came out a year ago, which people thought was some version of the rules, but it's not. So we have to see, that's why I keep saying we have to see where we are in a year, how many consent managers are there, what form they exist in, how much the government has permitted, and then you can start talking about integration. So on the consent manager question, I'd say wait and watch. But on the rest of it, I don't see necessarily why the 18-month timeline would be affected, because that's a whole other process. That's something you are supposed to do. In the government's conception of this, consent manager is simply an add-on that you would add on to your existing sort of interface.
Got it. Got it. Yeah, I think we can move on from the topic of consent managers. If you have any more questions on consent managers, please keep posting them. We will try to get you responses. But as Puneeth said, there's a lot of wait and watch going on here. It is a different breed altogether that is different from an account aggregator or something like that, and with a different idea in mind. But how this practically works out is yet to be seen. On your point about what legality is doing to figure it out, we are also working on the same problem of interoperability. I think that is the key problem here to solve. One consent manager can be used across all of these different sources, and how what that looks like in an integrated large enterprise setup. Yeah, but please keep those questions coming based on Puneeth's input, and we will send you answers later as well. And I think the next topic that we can talk about is fiduciary and processor relationships, right? Because we're getting a lot of questions about fiduciary and processor relationships as well. So, well, within fiduciary and processor relationships, you mentioned how important it is to close out your third party contracts, right? Now, what kind of safeguards can be added to these agreements to manage your liabilities in the case of defaults? Because there is a lot of spread of personal data to these third parties. Some of these third parties may be organized and other may not be organized. What are some two, three chief, like top of mind safeguards that can be added to this agreement, or a framework in which you can think about it?
Sure. And I think that dichotomy between organized and unorganized sectors is very important to keep in mind here. So, for instance, in the BFSI sector, you already have the outsourcing guidelines. You have a lot of guidance from the regulator on how you're supposed to engage third parties. So, you would just use that as a sort of guideline, you look at the penalties and the statutes there and pass them on. For other sectors, I think we have to wait for guidance to evolve from the DPD. So, that's how we see maybe through disputes over time, there will be some clarity on how we might interpret the fiduciary processor relationship. But what is clear is that the fiduciary is ultimately responsible. So what you need to be very careful about is how you separate out your obligations between you and the processor or other third parties. And as of now, you would use the standard contractual tools, you would have back-to-back indemnities, you'd have statutory fines that you might pass on. Because in this interim period, I think everybody is concerned about these protections. So for now, you want to make sure that as a data fiduciary, the two or three things I want to keep in mind is have an oversight mechanism in place. So that could be through audits, or that could be through inspections where you check for compliance from time to time, because that's your role. You have to drive compliance. Second, make sure that for you clarify in terms in the event that there's a breach or there's a this thing, there is some other fault on the side of your side or the process side. The role allocation is clear. Who escalates to whom? How do you report to each other? And finally, as I was saying, indemnity, make sure you protect yourself to make sure that no sort of you're not held, if you are held liable for the fault of a data processor, you're able to pass that on. The last one I recognize is hard because I know most data processors are much smaller than data fiduciaries. So again, this is something we think will evolve with more jurisprudence on this through the DPP.
Got it. So one question that is there in the chat, and that is a very interesting one. is when there is, a joint controllership, right? And we see a lot of a joint fiduciary nature, and we see a lot of this playing out in the industry, right? So, for example, if you have a fintech that is responsible for sourcing leads and matching pre-approved offers and passing them on to a creditor, or if I open a bank account, I get an insurance policy with it as well. There can be a lot of permutations and combinations of these sort of partnership arrangements that are out there. And in this case, of course, both of them are fiduciaries, both of them are processing the data. Now, if we were to break it down and have some sort of a framework to plan for this, then what would be the methodology to collect consents and manage data principal rights in these scenarios? Of course, not to get too specific, but to have a general sort of principles in mind.
Sure. And again, this is a quirk of our law that's not required anywhere else, where one, the data processor basically has no statutory obligations. It's passed on through the data fiduciary. So who is the data fiduciary and what the responsibilities are becomes very important. And unlike with the GDPR, there's no legitimate interest or contractual necessity or very limited reading of legitimate interest. So what becomes important, that's why you would start seeing more data fiduciary to fiduciary relationships becoming more prevalent in the sector. So the example you gave, the bank and the fintech, is very interesting because this is something that predates DPDP as well. What we've generally seen is usually fintechs or other technology providers to financial institutions are very happy to take on the obligations because they're essentially using that as a source of revenue. So they're happy to take on compliance obligations like taking on consent, putting in place whatever requirements there in the RBI outsourcing directions, putting in place security measures, and then passing that data on to the financial institution. A lot of times you've seen it packaged in a way where the bank or the financial institution doesn't have to do a lot, where the fintech kind of takes, or the technology service provider takes care of that. That's a very clean framework, which is very easy to do, but that's not actually what plays out in reality. In the insurance example where you gave the two sort of comparable entities packaging services together, I think that's where I think companies need to spend a lot of time thinking through their relationships and their data flows, because there your fiduciaries on an equal footing, you might have an equal sort of commercial interest in it. So you want to spend much more time thinking of your data flows and what obligations you're willing to take on. This is again a situation where you might want to seek counsel on exactly how you structure these sort of arrangements, because it's not always straightforward. It changes from sector to sector. It changes based on the kinds of information you're selecting. We've seen like franchise models where both the sort of franchisee and the parent entity are both data fiduciaries. The bank and financial service providers, another example. So I think there are quirks that each sector will have to think through. And the kind of arrangement, sorry, to go back to the initial question of what framework, this would be a data sharing arrangement. It would not be a DPA. It's a very academic distinction, but it's very important here because what you're essentially doing is only sharing data. As per the law, you're likely to have the same kind of responsibilities. But making that distinction in this framework is very important because if something goes wrong in the future, you'll be able to show this document to say that this was the bank's responsibility, this was the insurance provider's responsibility.
Got it. Got it. Yeah, I think definitely as a starting point, it's supposed to be a data sharing arrangement. And so there's so many factors that you listed out that you have to keep in mind. This is definitely something that will require a lot of head scratching and definitely require some legal sort of help to be able to solve for in specific bespoke scenarios. So want to quickly touch upon the theme of significant data fiduciaries. We might come back to third parties based on the questions, but significant data fiduciaries, we have a lot of backlog of questions. So let's go over those. But the first question, of course, that we're getting is how do we know who's a significant data fiduciary? Is there a list that is out yet? There is a broad criteria in the act, which maybe you can touch upon, but really, who is a significant data fiduciary? Can you provide any sort of direction on that, please?
Sure. So again, like you said, there's no list out yet, but there will be in due course of time. But there's a few useful hints in the framework. One is that it's one of the last things that they're going to notify. If you've seen, it's not just 18 months; it's 18 months plus notification, which means it could take even longer than 18 months because the provision around SDF significant data fiduciary will take into effect 18 months from now. But the notification could happen anytime after that. So it's a continuing process. The other thing is, I think you touched upon Rule 8.3 in the beginning, where you have to hold on to logs for a year after processing. One of the purposes for which you have to make the logs available is for MATI to make a determination about whether you're an SDF or not. So you could be an SD, you could not be an SDF today, and that could change 5 years from now if your sector becomes more critical. So this is going to be a continuing evaluation, and there will be notification from the ministry. to figure out whether you're an SDF or whether you're likely to be an SDF or not. I think, again, there's several hints just based on how both the SPDI, DPDP framework have played out. There's been enough hints from the government to suggest maybe the banking and like healthcare sectors they're looking at. If you see, a lot of banks have been designated as critical infrastructure providers under the IT Act already. If you're handling children's data, maybe keep an eye out because there are heightened regulations. So maybe go through the framework and figure out if you're subject to any of these heightened requirements, heightened obligations already. If you're a big tech company, again, you're likely to probably fall into this because just simply the number of times the government has called out special companies. That is broadly what we can say. But what I can say, and I did see like some specific questions on what does an SDF have to do this? Do they have to do that? We don't know at this point. But there is a little bit more time as an SDF for you to figure out whether you're an SDF or not. But a lot of the compliance is in place. I would imagine a lot of these sectors are also have their own regulations, like the healthcare sector and the banking sector, for instance. So some of the measures that may come through, you probably are doing through your sectoral regulators already.
Got it. So broadly, SDF is an ongoing exercise, which is a very interesting point that you brought up. As you expand in size, you keep going closer and closer to the SDF requirement. And of course, there's the sensitivity angle, which means that if you're a regulated entity, like maybe a bank or an insurance company or something like that, you're probably likely to be qualified as a significant data fiduciary. I think there are a lot of questions about requirements for a significant data fiduciary. So, for example, should a DPO be as appointed only for a data fiduciary, only for a significant data fiduciary, or is it required for a data fiduciary also?
You would, in the ordinary course of things, appoint a DPO or a grievance officer anyway. As I was saying, the structure is flexible. Comparing this to SPDI, for instance, you had to have a grievance officer, which is equivalent to a DPO in some ways, but not really. So I think they've left that flexibility, but you still have the obligation to deal with grievances. You still have a lot of the other obligations that a DPO would undertake if you are processing personal data. Yeah, sure. You don't need to have a designated DPO, but you definitely have to have some person or some department in charge of it, even if you're not an SDF.
Got it. Got it. And on the SDF point, there are requirements for an SDF to do due diligence and DPIAs. Now, this is some one change that has come in the rules as well, where the scope of due diligence has been increased to include technical measures, including algorithmic processing. So, what does this actually mean? Like, what does this due diligence mean, and how does this obligation differ for an SDF?
This is a new provision that came in, obviously, in the face of the dramatic developments we've seen with AI in the last couple of years. So this came up also in more recent iterations of the framework. The idea is simply to look at the harms that algorithmic processing can create and to counter that. And since you're an SDF, since you're subject to these heightened obligations, I think the idea with the government is you need to be able to foresee some of these harms. If you look at the recent synthetic content guidelines that came out for significant social media intermediaries, I'm just drawing a parallel. It's similar. They want you to proactively take steps to make sure that this is not harmful. You can debate the merits of it. I'm not doing that right now. But the expectation is that if you are using algorithmic decision making and that can cause harm, you need to be vet that in advance, take due diligence measures to make sure that doesn't happen. So to give you a quick example, an example of algorithmic decision making, say again, going back to the BFSI sector, you are making decisions on whether someone qualifies for a loan or not. You're making decisions on what sort of services you would give a person, and you're using an AI tool to help you, or you're using some soft because it says technical and algorithmic measures. So it could be even something more basic. You're using like a CIBIL score or something like that. How you're using that technical or algorithmic tool to come to that decision should not be harmful. So you should be, for instance, using it to discriminate against a particular class of people. There isn't, again, a lot of guidance on this. I'm just giving illustrative examples, so please don't hold me to it. But this is the kind of things they want you to be wary about. If you're deploying a lot of new and emerging tech to make these decisions and you're an SDF, you need to be a little cautious about it. So again, to take a step back into the AI world, the way they would do this is by making disclosures to mitigate risk, by making disclosures around their models and weights and things like that. There is no guidance at this point, but when we get to the point where this provision starts getting implemented, as I'm saying, it's 18 months plus notification, then you might want to start thinking about what you might do to mitigate these risks. There's a whole laundry list of industry practices that you can go back to, but we'll also have to wait for the government.
Got it. Got it. We're getting questions also for cross-border data transfers. And since we're talking about significant data fiduciaries as well, the first obvious question is, are there any special restrictions on cross-border data transfers for fiduciaries, or for significant data fiduciaries that are coming out of the rules? And if so, then how do you grapple with them? I'll keep it to the first question. Are there any requirements for significant data fiduciaries for that restrict cross-border data transfer?
Sure. Maybe I'll start with the whole framework and then we can go to
Yeah,
different categories.
yeah,
Because again, data localization has been a hot topic for the last decade. So cross-border data flows per se are permitted. That's the good thing about like the 2023 Act that was eventually passed. Is as a principle, it's permitted. It's restricted only to certain countries or with certain specific restrictions that the government may come up with. So we moved to essentially a blacklist approach, where again, a very hypothetical scenario of a country close to us wages war, which may have happened very recently. They may put that country on a blacklist and say, don't send personal data there. There's security considerations. That's the first level of restriction. The second level of restriction is they might prescribe specific conditions for specific classes of fiduciary. That's what you're referring to is the SDF rule that's there in, I think, Rule 13 of the DPDP rules, where the government has said that a committee will be set up and this committee will come up with rules on specific restrictions that would apply to SDFs. So that does not exist on date. So again, in terms of timeline, you're looking at 18 months and then SDF being notified and then this committee being set up, which might then tell SDFs that certain categories of data you might localize. Crucially, what's missing in all of this is the mode of localization. Again, there's a range of options when you come to data localization, right? You could have hard localization like the RBI does, where there's practically no storage outside allowed. You can take it out for, I think, error reporting and things like that. But it's hard localization. All the data needs to be here. Your servers need to be here. If you're using cloud computing and all of these technologies, you should make sure that the residence of that data is in India. That's the hardest form of localization. More softer localizations is they might ask you to keep a mirror copy. I think the 2018 or 19 version of the bill, DPDP bill, had that. So there's a range of options that there's no clarity on. I'm sure there's a lot of questions on how you might architect this storage. On that, we'll have to wait and watch. The other two restrictions I want to quickly touch upon is the DPDP also Act clarifies that if there's a more harder form of localization that exists, there's a stronger restriction in your sectoral laws that will trump the DPDP Act. So say the DPDP Act is silent on whether financial data needs to be stored in India, but the RBI says financial data needs to be stored in India, payments data, sorry, which it means a specific sectoral law, the RBI's localization mandate would trump the DPDP Act. And the final category of restriction, which is also there in the DPDP rules, is that, and this applies to all data fiduciaries, if you are sending data outside India and a foreign government entity or someone who's under the control of a foreign entity, again, I don't know how you determine that, requests you for data, then you're not permitted to do that. Or the government may impose conditions on how you share data. Again, this comes from the Snowden revelations and the fact that foreign governments can access data. That's the anxiety this week. That's broadly
got it.
the data
Got it.
localization.
Super comprehensive, I think. Covers all the aspects. I think even if you're a non-SDF, the negative list requirement will apply to you. If you're a significant data fiduciary, then there may be some special restrictions that apply to you. There are, on top of that, harder regulatory restrictions that also apply to you, which will obviously prevail. And what is the nature of this localization, which is a bunch of nuances that you went into about the nature of the localization and how to exactly grapple with this question on an ongoing basis, I think are going to be really valuable to our audiences. Quite a rapid fire round of questioning that we have going on here. It's exciting for me, definitely, but I think you are in the spot answering all of these questions. Thank you again for that. And I think I speak for all of the audiences when I express my gratitude for this. So, next, maybe we can touch upon, we're getting a lot of questions. Oh, there's one more question on cross-border data transfer that is coming up here, which is, I think, super relevant and it's a bit specific and practical, which is that AI models, right? Just as an example, AI models, there is one country or a couple of countries that are monopolizing these AI models, which introduce a lot of efficiencies in how you do work. So, of course, if not the business, then at least the third party provider that is serving the business is definitely going to be using technologies that involve cross border data transfer. So, as a significant data fiduciary, how do I handle that? Do you have any broad, again, a direction in mind, like the sort of things that you should think about or the sort of steps that you should take to validate this?
That's a super fascinating question that I'm happy to go into detail offline about. But again, like you said, broad directions. This is a question that's been on the government's mind as well, because with AI upsets the whole apple cart, right? The way you think about processors, fiduciaries, changes. AI has its own classification of deployers, developers, end users, and things like that. So within AI, it becomes super tricky. Where does the model reside exactly? Where is the sort of the end user computer data stay? There are questions around residency there that's slightly different even from like how cloud products are deployed and stuff like that. There is no clear guidance on how AI systems need to localize because as on date, that requirement doesn't exist. Like I said, the RBI direction is fairly clear where it talks about payments data. So it's part of a payment instruction, you would localize it. So within SDF, you'll have to wait and see what categories of data this committee that they will set up comes back and tells you need to localize. Maybe they'll say your model description, your model weights and stuff like that you store in India. I know again, these are technical questions. Like I said, I'm very interested in discussing offline. But I think they might, I don't see them going to that level of guidance yet because the government, if you see the recently released AI guidelines that MeitY came out with, they're very clear that they don't want to regulate AI too strictly. So I'd be very surprised if the SDF turned around and said all AI providers need to localize tomorrow. Again, we're speaking 18 months plus a few more months or years after that. So we have to wait for clear guidance. But the limited point is with AI changes this whole framework that I just described. So I think the government will also have to sit and revisit how they drafted these provisions in that context.
Yeah, absolutely. I agree with you because if the broader regulation, the broader view is to promote the use of AI, and yet, I can't have a chat, I can't use a chatbot or something like that in a lead generation flow or in a verification flow, then that becomes really problematic. Maybe you're right. Maybe the government will come out with some sort of a specific regulation around. Also gotten a lot of questions around retention and deletion, and we're also running out of time. So maybe we will cover a last few topics here, last couple of topics here, and we'll try to summarize all of the questions as much as possible. So about retention and deletion, the key question here is that the law says don't keep the data. If consent is withdrawn, then delete the data unless you require it for a legal purpose. So how does consent withdrawal, how does an erasure request work vis-a-vis the data retention requirements that are prescribed by sectoral regulators? Which one should I weigh and how do I weigh them together?
Yeah. Again, just starting from the principle of the retention requirement, which is again standard across most privacy regulation, is first is purpose. If you've collected data to provide someone banking services, until you finish providing those services, you can hold on to that data. Second is sectoral laws, and sectoral applicable laws, they trump even purpose in some situations. So purpose is linked to consent. So to your question, if I've given consent and I'm withdrawing consent, there's also provision which says that the data principal needs to bear the consequences of withdrawing the consent. So if you're unable to provide services, you need to clarify to them. And the moment they withdraw consent for that specific purpose, you need to stop holding it on for that purpose. Now, a situation where that's trumped is where there's a specific law applies. So again, going back to the banking example, under PMLA, you might have to retain it for 5 or 10 years, depending on the type of institution you are. Then that period will always trump whatever request data principal might have. So say again, for the sake of an example, you've collected three data points for providing banking services, but 2 of those you need to retain under PMLA. You then have to delete the 1 data point, which is not required for PMLA, and hold on to the other 2 data points so long as the PMLA purpose continues. Now, the really important thing I want to flag here, and something we've encountered with some of our clients, is people sometimes hold on to it saying we're holding it on for compliance, but then start using it for marketing and other purposes. That is a strict no-no. So if you go back to a lot of complaints about the notice being strict and like the specific purpose needs to be outlined, it's for this. So that purpose mapping is also done, that you've held it on only for this purpose. You're not then sitting on that data and using it for something else. That's broadly how data retention works. But if I know there's more specific questions, I'm happy to go into those.
Yeah, I think that does answer a lot of questions. One question that does come up over and over again and here as well is that then what use is the consent? Like how do I reconcile the consent with data retention timelines? For example, can somebody really come in and withdraw their consent for KYC? Can somebody really come in and withdraw their consent for any other PMLA requirement or anything like that?
No, you can't withdraw consent for a legal obligation, right? There's 2 distinct concepts here. There's a legal purpose and a legal obligation. So when I've consented to you collecting my data for providing a service, that's a legal purpose. So once I withdraw that consent, you, like I said, you have the right to stop providing that service to me as well, if it's essential for you to use that data to provide that service. The second category is a legal obligation. So sometimes a KYC is also legal obligation independent of you providing a service, right? So if you have to do KYC for anti-money laundering checks, if you have to do KYC to retain that data and use it for any regulatory sort of disclosures, you have every right to hold on to that data for longer than whenever someone withdraws their consent. The only point then there is you cannot use it for anything else.
Got it. Got it. I think there are a lot of questions also about, so I think here is where we can close retention and deletion. You've covered these aspects. Of course, like where legal requirement is an absolutely different basis for processing the personal data, and you must see that separately. That does put this question to rest. All these purposes are almost mandatory if you want the service. The next we can move on to one-time notices. We see a lot of questions about one-time notices, and I think all of them can be clubbed into two broad categories. Like, firstly, to whom do I send this one-time notice? The two scenarios is, if I've collected consent before already, do I need to send them a one-time notice? And what if I have not collected consent before the law comes into force? In that case, do I have to send a one-time notice, or do I have to take consent again?
Sure. So to first clarify, the requirement is to only give a notice. You don't have to collect consent again. The requirement is simply that you notify somebody that I have this data that I've collected about you and I've had it for such and such time. So there's no requirement that they have to consent again. Of course, there is the danger that someone might see that and say, hey, delete my data. I don't know why you have this. That risk exists. But the law does not require to go back and take consent again. The second question you asked is an interesting one, is if you haven't taken consent before, do you have to go give a notice? Strictly, if you read the law, you can take a slightly risky interpretation that you don't maybe have to go give notice again. But that, like I said, that comes with it risks, because if there's any data breach in the future, if there's any other investigation, they can come back and say you didn't even have consent to begin with. Why will you at least not send a notice? To be on the safest side, you should probably in that situation try and get consent to the extent that's possible, because you continue to process that data under DPDP Act. And again, this is a mix of legal interpretation and how much risk you're willing to take. So it's a bit of a commercial and legal judgment that you would have to apply at this point. Yes, so strictly speaking, you can argue that I didn't take consent to begin with, so I don't need to send this notice. But then the question becomes, on what basis are you processing this data under this new law? You would have to demonstrate that. So for that purpose, you will need to take consent at some point, especially if you're a B2C business, right? You will have interface with the customer. So there are many opportunities to go get that consent.
Yeah, that would be a pretty gung-ho interpretation of the law, that if I have not taken consent already, I don't need to send a one-time notice. And the really key important takeaway is the other thing that you mentioned. It's a legal plus business call. The government has shown you a direction with the act that these are things that you need to do. But of course, when you get into the gritty details, a lot of them become very difficult to understand, and that's where you need to take business, legal, technical, everything together. You have to think about everything and achieve the broader direction, but at the same time, just implementing it to the black letter might become very difficult. We are at the end of our scheduled times, and I just have two more questions for you so that we can cover the scope of broadly all of the questions that have been asked here. One is about children, like tracking children. Like, what exactly are the contours of this? The tracking of children is not allowed, but at the same time, there are some exceptions, specific exceptions. And also, there is, you can track children now to not serve them advertisements or not serve them problematic content. So, as an edtech platform or like a learning sort of a platform that is doing a lot of marketing around this, that is doing a lot of work on this, how do I think about this?
So to start off with, again, the purpose is to protect children. That's why the bar exists in the parent law, which is you can't you can't track or monitor children the way you would your other users. So that bar just exists as a principle. There are very minimal carve-outs, and I want to emphasize that this is minimal, and these are for purposes that are generally thought to be beneficial to children. So the example you cited, where you're allowed to track them to ensure they don't get harmful content, that's a bit of a tongue twister, but basically, if you are doing something to protect the child and you need to track them for it. So say you are running a platform where there's both adult content and children's content. And this was something that was flagged to MeitY during the sort of deliberations of the act and the rules. You want to figure out who children are for very obvious reasons of I don't want to serve adult content to children. So for that limited purpose where that content is viewed as harmful to the child, if you want to separate it out, you can track them, again, for that very limited purpose. So the other examples in the schedule are also very limited purposes. I would not rely on them as excuses to start tracking children's data. On the edtech platforms, again, in the final draft rules as well, there was arguments made to expand the definition of educational institution and include edtechs. If you see that hasn't been accepted. So again, you need to read all these exceptions extremely narrowly.
Got it. Yeah, got it. So one final question that I want to strike off from here that we haven't touched upon is the timelines associated with data principal rights management. Right? We have a 90-day timeline that has been associated with grievances. How are we supposed to look at it? Firstly, is it for a response or is it for a resolution of the grievance? Secondly, does it apply only to grievance or does it also apply to access, nomination, erasure, these sort of requests?
So again, a lot of this, there isn't guidance in the DPDP Act per se on what constitutes grievance, but there is a lot of guidance we can take from the intermediary guidelines, for instance, and other frameworks, or even the erstwhile SPDI. I don't think MeitY is going to come and tell you this is a grievance, this is not a grievance. You can expect to apply your judgment a little bit, but if somebody is making a data access request, it's very hard to argue that's not something that you need to respond to within 90 days because the 90-day timeline has been given, and it's fairly generous because the SPDI timeline used to be 30 days. So if you're exceeding that timeline, again, this is an area that requires clarification, one, on whether a data access request is a grievance or not. But in the absence of that, it would be safer to assume that you still have to stick to the 90-day timeline, even in the case of a data access request or a change in data access request, because again, there's scope for the data principal to go complain about you, right? And if there is a complaint and you haven't fulfilled it, I don't think you have very good legs to stand on to say that this is a request, this is not a grievance.
Got it. Got it. I think that's it. We will have to sum up. We have answered a lot of these questions that were raised by people. And I think thank you so much for coming down and giving us an hour of your time for answering these questions. I think people clearly from the attendance and the sort of questions that were coming in, people really wanted to hear from you. And of course, that's not a surprise. This is you taking out time to answer these specific questions for this big audiences. Any takeaways that you'd want to leave people with here based on the sort of questions that have come up? Any takeaways that you'd want people to have in mind?
I think it's the same thing I started with. I think it's now time to shift focus to operational questions about making sure your organization is ready for DPDP compliance. While there are issues that you and I just discussed, and I'm sure there are many nuanced questions that we need to go through, I think you can figure a lot of those out through the course of building compliance internally or through the course of using software or platforms that exist to help you with compliance, like the stuff that you guys are building. I think those sort of questions will, of course, be there, but that should not be a reason for you to not start with compliance. And now the clock is really ticking for professional DPDP lawyers like me. I think it's nice to see an actual timeline we can point to, because this has been a question for almost a decade now, and when it will come into effect. We have a very clear answer for that now. So I guess my only takeaway is that start thinking about operationalizing compliance and how you will start instituting a lot of these measures, because that for me is the much trickier part.
Perfect, perfect. So yeah, lot of questions that we are still getting. So just two, three things on that. If you are raising this question, it may have been answered before. If it has not been answered before, we will send you written responses to as many questions as we can answer over here. If there is also another webinar that Puneeth was a part of, in which he shared a lot of wisdom around a bunch of different topics. We will be sharing the link for that also. So maybe you'll be able to find those answers here as well. And of course, for your very specific question, you can reach out to Puneeth offline and engage in. But that is, I'm just really glad that we could provide this platform for this audience to engage with you. And I'm really glad that you could take out the time as well. Thank you so much, Puneeth.
Yes, thanks everyone. It's always a pleasure to speak to you.